Since you've received a notice to vacate, what I'd like to do is briefly go through with you the eviction process in Texas. It's important that you understand at every step that you have certain legal rights and there are certain duties that will fall upon your shoulders to protect your rights. You've received this notice to vacate from the landlord. It does not mean that you actually have to vacate the premises within the 3 days that the landlord has given you in this notice. This notice, as you can see, demands that you vacate the premises within 3 days. But you do not have to do that. It's a prerequisite for the landlord to send you this notice before the landlord can file suit in Justice of the Peace Court. That will be the next step for the landlord if you and the landlord are unable to resolve the matter. Now, if you think at this point that there may be a possibility that you can resolve this dispute with your landlord, I suggest that you go talk to the landlord and see whether you can resolve this matter. There is an eviction hold-off agreement in the forms that you may wish to use if you reach a resolution with the landlord. And if you are able to reach a resolution with the landlord which satisfies you and which is agreeable to the landlord, I suggest then that you and the landlord use this eviction hold-off agreement. You should both sign it. It will protect your rights in case the landlord tries to proceed with an eviction even after you have reached this agreement. Now, if you're unable to reach a resolution with the landlord and the landlord tells you that he simply wants you out of the property, what is the next step that the landlord must take in order to evict you? The next step after the expiration of the 3 days given in this notice to vacate is for the landlord to file a suit in the Justice of the Peace Court. Once the landlord files suit in Justice of the Peace Court, you will receive a copy of the lawsuit papers from the constable. Generally, those papers are delivered by a constable within 1 to 3 days after the landlord actually files the suit in the Justice of the Peace Court. Those papers are called a citation and a petition. The landlord says in the petition that he wants to evict you and gives the grounds for the eviction in the petition. The citation is the paper that explains to you that if you want a jury trial, you'll have to make a jury request and pay a jury fee within 5 days after receiving the papers. The citation also tells you when you must file an answer with the court or appear in court in order to protect your rights. Now, it is extremely important that when you receive the citation from the constable, that you read it carefully and determine exactly when your answer date or court date is. Now, depending upon which part, or depending in which part of the state you live, you may either have to actually appear in court on the date stated in the citation, or it may be necessary simply to file an answer with the court by that date. In most cases, answers may be done over the telephone, but you need to read the citation to see whether a written answer is required. You also need to read the citation to determine whether you must actually appear in court on a certain date. The citation will answer those questions. Once you've determined your answer date, it is generally a good strategy as a tenant to wait until the last day to file an answer. Obviously, if the citation just requires that you appear in court at a certain date, then you need to appear in court on that date. But if it gives you a time by which to answer, as a matter of strategy from a tenant's perspective, it's good to wait until the last day to file the answer with the court, but it must be done before the deadline or you will lose by default. Now, once you file the answer with the court, or if you appear in court for a hearing on the date set in the citation, the court will either hear the case on the date you appear in court, or after you answer, then schedule a court date for you to appear. Regardless of whether you appear in court on the answer date for your trial, or whether you answer and then appear in court at a later date, there are certain things you must remember when you appear in court. The judge is there to determine who is entitled to possession and whether you as the tenant have violated the contract with the landlord. The judge is not there to determine whether you are a good person or a bad person. The judge's role is to determine whether you, the tenant, have violated the terms of your lease and whether the landlord, in seeking to evict you, has complied with his obligations under Texas law and the lease in order to properly terminate the lease. So it's important, if you believe that you have a defense to the eviction, to take with you a copy of the lease, to take with you to court any documents that you think may be important, and certainly if it is a case in which witness testimony may be important, to take with you to court those persons who have information that you believe the judge may wish to hear. If you do not take your documents or do not take your witnesses, then the judge is not going to hear their testimony or be able to look at those documents. Once you appear for trial, then the judge is going to call your case. But let me back up a second. You should appear in court on the date set, either after you answer or on the date set in the citation, on time. Do not be late. If you're late, you may be in for a rude surprise in that you will find that the judge has already ruled in favor of the landlord because you were 5 minutes late to court. So you need to be certain that you appear in court on time. Once the case is called by the judge is going to give the landlord a chance to tell his or her side of the story and will then give you a chance to respond. If you are claiming that the landlord failed to give proper notice, or if your defense is that you properly paid the rent, or if your defense is that you have not committed the lease violation, then you will need to explain that to the judge. And the judge is going to listen to your testimony, listen to the landlord's testimony, may have some questions of you and the landlord, and if there are witnesses who are important, may ask the witnesses for a statement. Once the judge has heard all of the testimony and considered all of the evidence, the judge will make a decision whether the landlord should recover possession of the property, that is, evict you, or whether you should be allowed to remain. If the judge rules in favor of the landlord, then you as the tenant have 5 days under Texas law in which to appeal. If the judge rules in your favor as the tenant, the landlord then has 5 days under Texas law in which to appeal.